Welcome, future barristers. Today we are getting into a really crucial and very examinable part of the UCPR for your bar exams, access to exhibits. This is all about the new Part 9, and we're going to make sure you absolutely master it.
Okay, let's kick things off with a classic scenario, something you'll definitely see in practice and could easily pop up on an exam. Picture this. The trial's over, you've won, and a journalist comes up to you. They want to see that one key exhibit, the smoking gun. So can they? Do they just get to see it? Well, the answer is buried in the rules we're about to unpack.
You know, to really understand a rule, to get it locked in for an exam, you have to understand the problem it was created to solve. And for exhibit access, the problem was a pretty serious gap in the old rules that left courts in a really awkward spot.
And here's the origin story. It all goes back to 2020 and the case of Bros v. Velasquez, No 8. This case basically blew a huge hole in the old rules. A non-party wanted to see some exhibits, but Judge Muir looked at the UCPR and found, well, there's actually no power here. Exhibits that are tendered weren't considered filed documents, so the court's hands were tied. This decision created a vacuum that had to be filled, which is exactly why in 2022 we got the amendment that brought us the brand new Part 9.
So how did they fix the Bros problem? The solution is Chapter 11, Part 9 of the UCPR. And like any good set of rules, it all starts with a simple, foundational definition. Let's start with Rule 448A. That's 448A. It's simple, but it's absolutely crucial. For everything we're about to talk about, an exhibit is only an item that has been formally tendered in court. It's not a draft document, it's not something just floating around the bar table, it has to be officially in evidence. That's the gate.
Okay, so here is the most important concept in all of Part 9. Think of it as a fork in the road. The rules create two completely separate pathways, and which path you take depends entirely on one simple question. Who is asking for access? Is it a party to the case, or is it a non-party, like our journalist?
First, let's go down the easy path, the one designed for people who are already involved in the case. This is all covered by Rule 448B.
So, for parties, Rule 448B gives them two options. Option 1 under Subrule 1 is super simple, just ask the registrar. And Subrule 2 is really strong here. It says the registrar must let you see it unless there's some specific court order in the way. Option 2 under Subrule 3 is the more formal route. You can apply directly to the court, and then under Subrule 4, the court has the power to make whatever order it thinks is right. Simple, right?
All right, now for the other path. This is the more complex one, the one that was literally created because of the Bros v. Velasquez case. This is about access for non-parties, and it's all governed by Rule 448C.
Now, the very first thing to burn into your memory about Rule 448C is this. That easy path, it's gone. For a non-party, like our journalist, there is no option to just ask the registrar. Subrule 1 is crystal clear. You must make a formal application to the court. It's the only way.
And that application has some strict requirements. Rule 448C, Subrule 2 gives you a three-step checklist. For your exams, just think identify, file, and support. You have to identify the specific exhibit you want, you have to file the application in the right proceeding, and most importantly, you have to support it with a sworn affidavit.
And that affidavit isn't just a bit of paperwork. It is the absolute heart of the application. This is where you see the real gatekeeping function of the rule. Under Rule 448C, Subrule 2, Paragraph C, that affidavit has to spell out exactly why you want it, what you're going to do with it, and this is the big one, whether you plan to publish it. You have to put all your cards on the table.
So once that application is filed, what happens? Well, Subrule 4 of Rule 448C gives the court a massive amount of discretion. It's not a simple yes or no. The court can grant full access, deny it completely, or do what it often does, grant access but with strict conditions, like saying you can see it but you can't publish it.
So how does the court decide? It's not just a gut feeling. Rule 448C, Subrule 5, tells us what the court is thinking about. It's performing a balancing act. It's weighing up big ideas like fair reporting and the principle of open justice against other factors, and ultimately asking, is granting access here in the public interest or in the broader interests of justice?
Okay, we've walked through both paths. Now let's put them side by side. This is the kind of direct comparison that is absolute gold for exam recall.
This table is pretty much your cheat sheet. Let's break it down. For parties under 448B, they have a choice. Ask the registrar or apply to the court. For non-parties under 448C, there's no choice. They must apply to the court. And notice the affidavit.
not needed for a party's simple request, but absolutely mandatory for a non-party. The key difference is the hurdle. For a party, it's a low administrative bar. For a non-party, it's a high bar of judicial discretion. All right, we have covered a lot of ground. Let's distill all of this down to the absolute core concepts you need to walk away with for your exams.
If you remember nothing else, remember these 5 things. 1. The trigger case was Bros v. Beluskas. 2. The definition in Rule 448A is an exhibit tendered in the proceeding. 3. The party path, Rule 448B, is simple, registrar or court. 4. The non-party path, Rule 448C, is formal. You must apply to the court with that detailed affidavit. And 5. The test under Rule 448C, Subrule 5, is that critical balancing act between open justice and the interests of justice.
And that brings us right back to our journalist. Knowing the rules is one thing, but the real art of being a barrister is applying them. So when that journalist asks for your client's most sensitive document, how are you going to argue it? How do you convince a judge that protecting your client's privacy serves the interests of justice more than the principle of open justice? That's the real question, and that's the job.